combat scenarios or training classes.
Yes, sir.
In use of force classes, it is used as a tool.
Yes, sir.
And there's actually exercises that you do where you have a marker and you're using simulated rounds and you're trying to create the same, they call it, you heard the term stress inoculation?
Yes.
You're trying to, may I push it? You're trying to create a scenario where you'll have them run, maybe go through dark scenario, rustle them up, and try to create this environment where the adrenaline is flowing, and then they have to respond appropriately within that 21-foot rule or get marked up by the marker.
That was actually part of the training that we did.
Yeah. And you'll know by the marks on whether you got stabbed, shanked, or sliced by that.
Yes.
Right? But it can be applied to a force blunt object.
Yes, it can.
Can you explain to the jury what a force blunt object is?
A blunt force object is anything that can, when we refer to it, and especially in a medical exam or in a murder situation, it's anything that you can be hit with that can cause serious bodily injury or death. It could be a stick, it could be a hammer, it could be a rock, it could be a golf ball, it could be anything.
And so a rock could be a deadly weapon.
We've had DPS shootings where they were attacked with a rock and were required to shoot.
I mean, have you heard scenarios where a golf ball is a deadly weapon?
I have.
Where a golf ball can take out someone's eye if it's thrown at them just the right way, and actually you've heard of situations like that.
Yes, sir.
And so there's no question that a hammer is a deadly weapon.
Correct.
Now the Tula rule. There's been another rule. You mentioned that you did a course, a force science course. And is there a force science sprint study that kind of adjusts the Tula rule a little bit?
There actually is. Force Science conducted a study based on the amount of time an individual can sprint under certain circumstances, and in another study related to that, or the same study related to that, they measured the officer's ability to transport depending on the amount of equipment that they had. The table that they came up with actually extends that Tula rule from 21 feet to about 25 to 30 feet in 1.5 seconds based on that particular study. It was a peer-reviewed study in the Force Science book. I didn't bring that with me, but it's part of the Force Science Institute.
And when I hear it say, you're not saying force science, it's force, like use of force.
Yes,
Force
F-O-R-C-E.
F-O-R-C-E, force science. So I want to talk about, we talked about apparent versus actual danger and what the law allows. I want to talk about taser, shield, and beanbag, okay?
Okay.
So we've seen tasers come out. We've heard about taser training. Would you agree that a taser is a compliance technique, not a defensive technique?
Yes.
Is there ever a scenario in a self-defense course or use of force course where if an officer is being charged out with a knife, a blunt force object, or a gun, and they have a taser and a gun, that they are trained to pick up the taser?
No.
So when I say that a taser is a compliance, not a defense technique, if you tell someone you're under arrest, get down so I can handcuff you, and they don't, they can be tased.
Yes.
Is there any course that the government can cross-examine you on or present to you where an officer is trained that if they're presented with deadly force, that an officer anywhere in Texas that you know of is taught to respond with the taser?
None that I've ever seen, and I will never teach it.
And why will you never teach it?
Because it's not the correct response to deadly force. That taser has the ability to move, to miss. It has the ability, depending on how far that individual is from you. Let's say you try to use a taser where a guy is charging at you with a knife and he gets within 5 feet of you, and that taser does connect. The problem is that in order to get a good taser response, those probes have to get a good distance away so that the majority of the muscles will contract as a result of the electronic voltage being sent through them, and it causes them to be immobile. But the closer you are, the less those probes have to expand, so they can hit here in a very close situation, only affecting a very small portion of the body, and you won't get that response to where they stop what they're doing. Also, clothing makes a difference in a situation. Moving subjects make a difference in the situation. And I've even handled shootings and been on calls where this has happened, where we have tased somebody effectually and got a good probe contact, but it simply doesn't respond to them, and they're able to rip those probes out and continue the attack on the officer. It is not the tool to be used to defend yourself from deadly force.
Now, So that's when we talk about a taser as a compliance, not a defensive technique. Do you have an opinion on whether officers in today's law enforcement world overuse the taser?
They do, and they use them inappropriately in situations. I mean, we will have officers try and use a taser on an individual with a knife, and I can show you video after video that I use in my training classes that are catastrophic as a result of that. But officers are doing that more and more because they've become to fear their ability to use deadly force to defend themselves, because they're concerned about not only repercussions from the department, but repercussions in the criminal world as well.
And being prosecuted like this?
Yes.
And you've seen that because they overuse taser at a compliance technique when it should be a defensive technique, people get injured.
Yes.
Not just the officer, but other citizens and other officers.
Yes.
How much force did any of the three officers behind me use at the scene against Melissa Perez when she was not charging at them with a hammer?
They didn't use any force. Their use of force in that situation was appropriate. If you watch the videos, when she was attacking, they used the appropriate force in drawing their weapons and being prepared to defend themselves against an actual or even an attempted attack. But when Melissa Perez stopped using force and backed off, you saw the officers holster their weapons. You saw them to retreat to tasers with the hope of being able to do that without having to use deadly force. But in every situation throughout this particular case, everybody acted appropriately when force was not being used and when force was being used.
And so we have no incidents where, and even when Officer Alejandro discharged his weapon to defend Sergeant Flores, he didn't keep shooting at her when she backed up.
He did not.
When the threat wasn't immediate, he stopped discharging the weapon.
Yes.
And would you agree in your experience that there's a couple of reasons why he shot left? Number one, under pressure, what is it called, and I'm not trying to embarrass him or be disrespectful, slapping the trigger. What does that mean?
There's a number of reasons that he missed, but slapping the trigger means that when you're on target, the whole idea in the firearms is to squeeze the trigger. You squeeze that trigger so you don't have movement of the weapon left or right, so you can stay on target. You get your sight alignment correct, and you squeeze the trigger so it's really the finger moving back like this. But when you get into a high stress situation, when you're excited, when that adrenaline dump hits and you're trying to defend yourself, that weapon comes up and police officers start shooting as fast as they can, and slapping that trigger, if you're right-handed, is going to cause that weapon to shoot to the left. And so that's why there are so many misses in officer-involved shootings. We're not as accurate as we are on the range because we're not under pressure, we're not under stress. We're concentrating on that trigger pull. But in high-stress situations, it's exactly what happens.
And you said a term, may I stand up, Judge? You said side alignment. I want to make sure the jury's always with us. So side alignment, these are I'm not, sorry guys, it's a fake gun. There's three sights. There's rear sights and the front sight, correct?
Yes.
And side alignment is aligning the front sight with the rear sight in order, and then placing those sights on your target, controlling the recoil of the gun, which is how you handle it. And you're talking about that slapping of it could
Yes.
cause it to do this.
And under controlled circumstances, it's easy to do, but in high-stress situations, it's not.
Right, but then also there's two other factors there. I mean, Officer Alejandro knew that Sergeant Flores was there, but he had no choice. So the natural tendency is going to be to stay away from his sergeant and try and pull left because Sarge was right here.
Yes, on the first volley, Sergeant Flores was right next to Officer Alejandro. In the second volley, of course, you've got now Officer Villalobos closer to him. But there's a third factor that I hadn't considered until a little later on. You have to look at, and I'm sorry, but you have to look at Officer Villalobos. He's 5 foot something. And if you look at him in the video, okay? Alejandro, I'm sorry, Officer Alejandro. If you look at him in the video, this is his position as he's firing. His shoulders are actually up above because he's firing over that rail. And of course, this is not where you should be. This is where you should be. And so his aim is off because of his height. His aim is off because of slapping the trigger, and he's taking into consideration what's around him.
Sarge, and then also that those shards of glass coming at him don't help either.
They don't help at all.
And you testified earlier that any one of those chunks of glass, if it would have lodged into any one of them, but Sergeant Flores was the closest, that could have caused serious bodily injury or death.
Yes.
And when can I push, Judge?
Yes.
I'm showing you what has been marked as Defense 41. Have you responded to either fights at bars and or domestic violence where glass were thrown and bottles were thrown at people?
I've handled those cases, yes, sir.
Would you agree that glass breaking on someone's face, I understand that there's wax in here, in the one in our situation there's no wax, which actually makes it more dangerous. Would you agree?
Yes.
Because it's easier to break without the wax.
Yes, sir.
It's not as heavy, but it's easier to break.
Correct.
Have you seen the effects of glass just cutting, slicing people's face,
Absolutely.
hurting someone's eyes,
Yes, sir.
causing serious bodily injury?
Yes, sir.
This is not like the Western movies where John Wayne and everybody's smashing bottles on people's heads, and those are sugar glasses
Yes.
for movies. Glass fights and glass breaking is a dangerous endeavor.
Just getting hit with a bottle or a glass is actually capable of having a skull fracture, and which will cause internal bleeding. That's what we define as a blunt force object, unless of course it breaks, and now we become sharp issues that we have to be concerned about.
And so actually, depending on the legal evaluation, the throwing of that candle glass could have been an aggravated assault against a peace officer.
It could have been, yes.
If it would have hit Officer Salinas in the head and fractured his orbital socket, that would have been SBI.
Yes.
Right? And then she would have been charged with aggravated assault in that scenario as well.
Yes, sir.
The fact that it hit his arm and bruised him, that doesn't mean that wasn't still an ag assault.
Correct.
Okay. So now, I want to direct your attention kind of to the idea of this shield, because a lot of talk has been about a shield. Are they called ballistic shields or blunt force shields?
There are two types of shield. They're called ballistic shields, and then there are impact and riot shields, and they're two different types
So
of
let's
shields.
talk about those. We've seen situations where maybe there's a disturbance, there's a riot, and then you have officers, if I may stand, Judge, there's officers that have kind of like this plastic.
It's made of polycarbonate.
And it's lighter than a ballistic shield.
Yes.
Much lighter. And then
Yes.
they have their asp.
Yes.
Or their mace.
Yes, sir.
And the purpose of that type of blunt force shield or riot shield is because you're doing this and you're spraying, or you're doing this and you're striking.
Yes.
Correct? That is the purpose of that type of shield.
That's correct.
The ballistic shield is not for that purpose.
It is not.
Ballistic means what?
Ballistic means it's capable of absorbing a high impact, a high velocity impact from a rifle or a high-powered rifle. They're designed to take that impact and distribute it across the shield without actually penetrating through the shield itself.
Judge, may I approach the witness? I'm handing you what's been marked as Defense Exhibit 125 for identification purposes at this time. Will you take the opportunity to look at that, and would you agree that that represents to be an SAPD
It does.
PowerPoint curriculum on what kind of training?
On ballistic shields.
Can you quickly look through there and see if officers are trained to use a shield against a blunt force object or knife?
I've looked through this, and I can tell you it is not.
How many other curriculums have you looked at through shield?
I look at, as a training county sheriff's office, I'm required to look at and approve curriculum for ballistic shields or any reporting that I do for another agency. So I have to have copies of their lesson plans and make sure that they're done correctly. And no lesson plan that's been submitted to me with ballistic shields talks about using that in any way for an impact
So
weapon.
nobody in Texas that trains on ballistic shields is trained to use them against hammers, against bats, against tire irons, or against knives.
That's correct.
Judge, this time we move into evidence, defense 125, and I submit to counsel for inspection and no objection.
That's admitted.
Well, we happen to have a shield here. I'm going to use my Vanna White here, Jason Goss. And so, dude, this is not a light thing.
It's not.
This is not the the shield that you're talking about for riots, where you're blocking and you're striking and you're blocking, the person holding this shield in a combat situation is not fighting.
That's correct.
They're the lead.
They're the lead.
And as we can see in those training, there's people behind them, whether it's a long rifle or handguns, they're positioned and formation behind them. Keep moving. And so they're going in because they're expecting gunfire, projectile, and they're expected to shoot a hammer or tire iron, and everyone's sitting there like Spartans or Romans. This is not what it is. This is for combat with firearms.
With firearms, yes, sir.
And is there any scenario where somebody would use this to breach an apartment against people with blunt force objects?
There's no training scenarios that I've ever seen.
Would you agree that the individual in the front, back up please, hammer versus shield, which one do you want? Somebody's got to go home. Which one do you want?
I want the hammer.
I do too, because he can't do anything. It's here. I can do this, pull down. Sorry, and then boom, come this way. I can come around. I can come around this way. This does nothing against a hammer in an open combat situation.
It doesn't. And also what you have to consider, and there's actually, information to show us that ballistic shield is designed to, as I said earlier, it's designed to distribute ballistic high velocity bullets and separate and distribute that across the shield to keep it from penetration. It's not designed to distribute low velocity impact weapons. And so if in this scenario, if Mr. LaHood were to hit in the area where Mr. Goss is holding the shield, that impact alone, just on the shield itself, on that impact alone on the shield itself could distribute that force through the shield itself and cause some type of injury to the hand or the arm that's holding it.
But it's ineffective against a hammer fight.
Yes.
And matter of fact, whoever's behind this person is going to have to use deadly force in defense of a third person against a hammer.
Yes, because this guy's
was made that.
You can do it,
Well, I know I need you still, brother.
okay.
Wish we had a better thing. So if this is the window, there have been some suggestions that put the shield up. That they put the shield in front of the window, and just what does that do to get Melissa Perez in custody?
It does nothing.
So would you agree that we have a shield holding the window, and now somebody's got to go through this door and still get into that engagement against a hammer, correct?
Yes.
So this changes nothing in getting Melissa Perez in custody.
It does not.
So tactically, this shield, and it seems like the 3 sergeants out at the scene and the other 13 officers figured it out. That shield was ineffective for this situation.
Yes, it was.
The tasers would have been ineffective for this situation.
They could have been, yes, sir.
The bean bags were ineffective for this situation.
Absolutely. When you're talking,
Explain that, please, why?
well, when you're talking about bean bags, again, remember you've got a projectile that's coming out of a rifle at an extreme amount of force. And the training that they will tell you is that if you use that bean bag within 20 feet, which around within 20 feet of the subject you're hitting, then it's entirely capable for that bean bag to penetrate the body and cause serious bodily injury or even cause death, depending on where you hit them. So you've got to be a good distance away from an individual for that bean bag, at least for their own safety, if you're going to use it, to make sure that you don't inflict that serious bodily. And in this particular situation, we know that distance that we're talking about, she would have had to have been on the other side of the room, and the officer still would have had to have been 20 feet away outside that balcony. It's not realistic.
And it's also, is it fair to say that it's mainly for an open field scenario where
Yes,
there's
it
not a lot of concealment or cover?
Absolutely. And again, in this situation, you're dealing with a small target. You're dealing with, yes, there is the ability for Melissa Perez or the police officers to have access to that window, but there's still an obstruction there to a degree for purposes of beanbag. But then there's also that moving target that you're trying to hit and be effective with, and it was just not
But
possible.
would you agree with this? Just the fact that the 3 sergeants at the scene and the other 13 officers were even talking about shields and beanbags, would you agree that they're still trying to at least contemplate a safer way to get Melissa Perez in custody, even though she didn't want to?
Absolutely, and that's with Sergeant Flores' intention by talking about. He took all of these things into consideration. Is there a shield? Okay, yeah, there is one, but is it really going to work? We've got less lethal information, but is it really going to work? And can we effectively put enough people on that patio to go through that door with a shield to accomplish our purpose? He took into consideration whether or not to use a key in this particular object. And if you listen to the video, when he asked for a key, he actually tells the maintenance man, but you know what? I bet that key's on a bunch of rings, and if we have to go through every one of those rings, it's going to alert her that we're coming, and so she's going to be able to attack. So we're going to take that out of the equation. Sergeant Flores took into consideration a number of ways to take Melissa Perez into custody as safely as they possibly could. And when his scenario and his plan actually came to fruition, she was not in a position to launch an attack. The thing that changed here was Melissa Perez attacking the
Her
officers.
actions changed it.
Yes.
So a plan is a plan until there's a plan B.
Mike Tyson made a statement, world heavyweight boxing champion. I don't know if you know who he is, but he made a statement and he had a quote. Everybody has a plan until they get hit in the face. And what he's talking about is every man that went against him in a fighting match had a plan how to beat him until he hit them. He changed that plan by hitting him in the face. Sergeant Flores had a plan. It was a plan that he thought out and went through all of the evaluations, and that plan was put into effect when he got in to try to make the arrest. Melissa Perez is the one that actually changed that equation and changed that plan.
But it was a plan that Sergeant Flores developed by taking input from other people.
Yes.
Considering every option he could, even options that weren't tactically applicable, and he made that determination.
Yes.
And it was approved. That plan, obviously, this is not speculation, was approved by Sergeant Rivera and Sergeant Robertson.
Absolutely.
And it was approved because by all the other 13 officers at the scene.
Yes.
Now, there was some mention about, I think Mr. Luna said 15 officers, all of them are in shape against little old Melissa Perez, and I'm not being disrespectful, but it wasn't as if they were in, may I stand up, Judge?
Yes.
If they were in an open field, one Melissa Perez, 15 officers, no hammer, no weapon, that's a different scenario than the scenario they were in.
Yes.
So we had a very narrow hall of entry. We'll call it point of entry.
Yes.
Very narrow. The back window was not a good way to enter, correct?
No.
Because it's a higher and it's a smaller window, and somebody is really exposing themselves. So that's not a smart way to enter, correct?
Yes. Correct.
And so at that point, it didn't matter if there was 1,500 officers out there. There could only one or two go in at a time.
This was not Melissa Perez against 15 officers. This was Melissa Perez against 2 officers who were going through the door trying to make an arrest.
And at the time she attacked, they weren't even going through the door.
That's correct.
I asked you at the beginning of our questioning, our discussion, of whether you had arrested other officers before.
Yes, sir.
I mean, and investigated them, arrested them, and helped prosecute them and send them to prison.
Yes.
And you're testifying here because you evaluated this situation with all your experience objectively, without a personal stake in this, and you believe that they were justified in their behavior.
I will tell you that in 47 years of doing this job and investigating these cases, I've made thousands of calls on patrol. I've made thousands of arrests on patrol. I've investigated hundreds and hundreds of cases that I've filed charges on with the state, and testified for the state in every one of those cases and supported those decisions. But when I looked at this case and I saw the rush to judgment to charge these officers, and I reviewed the investigation that was done by Detective Soto to charge these officers, and the misapplication of the law, and the misapplication of the reading of the law, and the misstatement of the facts of this case, there was no way that I could not testify on behalf of these officers.
And that's because you're getting paid a lot of money, right?
I'm not getting paid a dime.
You're not getting paid a dime?
I'm not.
So not even a per diem, nothing?
Nothing. I haven't been paid since day one.
And so you've been here for over 4 weeks, correct?
Yes.
And as you sat there as an expert can, you haven't been paid a dime?
No, sir.
How many hours did it take to review this case and do a thorough investigation that should have been done?
I've spent 300 to 400 hours or more on this case
And you have
over
not
the
been-
last 2 years.
Not even a Happy Meal, nothing?
Nothing. Well, I take that back. I think Mr. Cifuentes bought us lunch one day.
Okay, well,
But that's about it.
That's your compensation.
Wasn't a Happy Meal, but
Good. He knows better.
Yeah.
But you're still working in your duties for Kendall County Sheriff's Office.
yes, but I'm not on duty at this point. Every action in my case on this particular case has been done off duty. I wanted to avoid any implications of misconduct or any appearance of impropriety on my behalf. So I have taken, all of this has been on my off time. I've used vacation time, and I work nights and weekends to make up for the time that I have.
Is that why you and I have been on the phone at 11 o'clock at night at times, because you're working at Kendall County Sheriff's Office?
Yes.
Pass the witness, Judge.
I'm wondering if you might take a short break here?
Yeah, I think there's a juror that wanted one last break before they close the doors, so let's go ahead and take a short break. We'll let you know when we're ready.
All right for the jury?
May be seated.
Yes, sir.
I want to cover some things that I want to be sure, and I hope not to repeat what's been said. But you did review grand jury testimony in this case, correct?
I did.
And would you agree that you reviewed transcripts of Chief William McManus's testimony in the case of Andre Vargas versus the city of San Antonio?
I did.
And he addressed that the San Antonio Police Department trains on Graham v. Connor, correct?
Yes, he did.
And you were in the training academy in 1989 when the Supreme Court came out with the decision of Graham v. Connor?
Yes, sir.
All right. And at my request recently, did you review a message that the chief sent to everyone in the police department back in March of 2016?
I did.
And in that message, did he explain to everyone that the San Antonio
Sorry?
Object to hearsay.
Sorry?
Okay. Did you rely upon the chief's message that he gave in 2016
I did.
as instructions from?
Or dire witness.
Yes.
Is this something that you relied upon in the course of your regular preparation for the training classes you do, or is this something you relied on simply because they gave you that information to look at?
It's something that I relied on because it was documentation provided for me to form my opinion as an expert on whether or not these charges were justified and the use of force was justified. And it was given to me by the defense.
By the defense, right? This isn't something that you came up with on your own, right?
No, sir.
It's not.
It's not.
Okay. I object. It's just hearsay.
Your Honor, I believe it's proper, but if need be, I can lay further predicate.
Okay.
Butch, would you agree that the chief of police, William McManus, when he gave that message, he was giving instructions to his police officers what he expects a reasonable officer to do?
Yes, sir.
And so when the chief of police gives an instruction to the San Antonio Police Department, is that something you, in your expert opinion, believe that police officers can rely upon in deciding what's reasonable?
Yes, it is.
So in that March 2016 message, did he indicate that he does not expect officers to retreat when faced with danger?
Yes.
Did he indicate that he expects officers to adhere to the Graham v. Connor standard?
Yes. As a matter of fact, he said he wouldn't expect the officers to be held to any higher standard than Grant.
All right, and fear or rumors that the department was going to impose higher standards that were more restrictive than Graham v. Connor?
He did.
All right. So based upon Chief McManus's testimony in the Andre Vargas case and his testimony, and his chief's message, would a reasonable San Antonio police officer believe that one must adhere to Graham v. Connor?
Yes.
All right, let's talk about, tell the jurors what TCOL is.
TCOL is the state licensing office for all law enforcement officers in the state of Texas. It's Texas Commission on Law Enforcement. In the past, it's been known as TCLOS, Texas Commission on Law Enforcement Officers Standards and Education, but they shortened it to TCOL. They provide information on the requirements that we need to have to pass the academy and be licensed as a peace officer. They also issue mandated training for us to keep our license and to advance in certifications as we are police officers.
All right. And does TCOL have a proved curriculum for officers' use of force?
Yes, they do. Excuse me. Yes, they do.
And you teach that course?
I do.
And you review the curriculum or outline for that course?
It is mandated, because it is a mandated course, I have to follow that curriculum and outline, so I'm familiar with it, yes.
And so does that curriculum apply to San Antonio police officers and all police officers statewide?
It does.
And does that curriculum teach the Graham v. Connor standard?
It does.
And what is Graham v. Connor, for the benefit of the juries?
Graham v. Connor is a United States Supreme Court case that dealt with an officer's use of force and set the standard and actually change the standard on how officer uses of force is going to be judged. Before Graham v. Connor, it was judged under the Eighth Amendment, cruel and unusual punishment, and that required some proof of an officer's bad intent or malicious conduct in the case to determine whether or not their use of force was justified. Graham v. Connor came along and changed that standard and put it under the Fourth Amendment of the United States. And what it did was it created an objective reasonableness standards. We're not going to look at whether the officer had good intent or bad intent. We're not going to look at certain circumstances that we looked at previously. We're going to set the standard to say that in order to determine whether an officer was reasonable in their use of force, it will be set on an objective reasonableness standard based on the totality of the circumstances.
All right. Now, would you agree with me that Graham v. Connor set forth several factors, and I want to go through some of those factors? You agree that there were several factors?
Yes, there were.
All right. And would you agree that one of the factors is that proper application requires attention to the facts and circumstances of each case?
Yes, they do.
All right. So I want to digress a little bit. Forgive me for saying, but you had an excellent PowerPoint presentation. Would you agree that it took you some time to put that together?
Yes, sir.
All right. And you were able to put that together by reviewing all of the available digital media evidence of the 15 officers on scene from beginning to end, correct?
Absolutely.
How many times did you review it?
You know, I didn't actually count, but if I had to, I'd say 20 to 30 times.
All right. And did you have the benefit of a complete transcript of each body-worn camera to assist you in your review?
I did.
And did that complete transcript have timestamps in the transcript?
Yes, sir.
And can you tell the jury whether having the benefit of those timestamps in the body-worn camera enabled you to evaluate the facts and circumstances of this particular case?
It did, yes, sir.
And can you explain to the jurors whether, in your opinion, Detective Soto or Captain Ben Geffen or Chief McManus would have been able to evaluate the facts and circumstances of this case when the arrest warrant was signed on June 23rd, 2023 at 6:23 or 6:45 p.m.?
That is not possible.
All right. And when you obtained quotations in your PowerPoint presentation, did you have to go, can you tell the jurors whether in counting the number of times she said she wasn't going to be arrested or the number of times she said the officers needed a warrant, whether you had to go to different body cameras?
I did. I had to review different angles and different cameras.
All right. And so by doing that, did that consume a lot of your time?
It did.
All right. And is that part of the reason why you have the opinion that there was a lack of careful attention to the facts and circumstances of this case when the warrant was obtained?
That was part of it, yes, sir.
All right. And so the that issue, what we know from what Mr. LaHood said is that there's different scenes,
Yes, sir.
and the initial concern would have been with the fire alarm system. You understand that?
Yes, sir.
And even though it's a property crime, the fact that it involves the safety of maybe 100 people in an apartment in itself would be considered a severe crime under the circumstances.
Yes, sir.
And would you agree with me that aggravated assault on a peace officer or attempted murder or attempted capital murder of a peace officer? And so at 1:40:51 or so, Melissa Perez, based upon your slide presentation, attempted to strike and did assault Jonathan Salinas, would you agree?
Yes, sir.
And would that be a serious crime?
It is.
And since we're on that point in time, if I could have that slide. Sure. All right, so Melissa Perez, from Officer Ramos' body worn camera, and the timestamp was 01/41/09. What do you notice about Melissa Perez's head at this time?
Her head is outside the window.
And what does that tell you about her ability to locate and visualize her target?
It absolutely makes it able for her to do that. She's able to turn her head and look in that direction, that 180 degree direction that she's capable of seeing.
All right, and you already have addressed that there was no obstruction, but the fact that she's able to stick her head out the window, does that further refute the claim that this Detective Soto made that there was an obstruction that blocked her ability to strike?
It does.
And based upon describe this moment at 01/41/09 on Detective Ramos' body worn camera, does that tell you whether he failed to evaluate this case by paying careful attention to the facts and circumstances of this case?
It was a clear omission of those facts and circumstances, yes, sir.
And you know that before 01/41/09 that she attempted to strike Jonathan Salinas twice.
Yes, sir.
And was that an omission that failed to address the severity of her criminal conduct at that moment in time?
It was a clear omission, yes, sir.
All right, and so when we fast forward, you can go ahead and take that down. When we metaphorically fast forward to the time that Melissa Perez attacked Nathaniel Villalobos at around I believe it was 1:51, 55 or so, was that also a serious crime when she attacked Nathan Villalobos with a hammer?
It was.
And was that also a failure to address the severity of the crime at issue?
It was.
And does that also show a lack of attention to the facts and circumstances of this case?
Yes, sir.
All right. And would you agree that when she was engaged in that conduct, she was actively resisting arrest?
I would.
And is that a factor that the Supreme Court in Graham v. Connor says should be taken into account?
It's an absolute factor, yes, sir.
All right. And in Graham v. Connor, does the court admonish the reader and judges that you must put yourself in the perspective of a reasonable officer? And in your review of this case, did Detective Soto fail to put himself in the shoes of Alfred Flores, Eleazar Alejandro, and Nathaniel Villalobos?
He did, and he admitted he did.
All right. And is that a violation of the directive in Graham v. Connor from our Supreme Court of the United States?
It is.
All right. And did the Supreme Court of the United States admonish that you must put yourself not only in the shoes of the officer, but you cannot judge them with 20/20 hindsight?
It does.
And did, in your opinion, your expert opinion, did Detective Soto attempt to judge them with 20/20 hindsight based upon his assumptions?
He did, and he admitted that he did.
And when he did that, would that be a violation of the directive in Graham v. Connor?
Yes, sir.
All right. Now, as part of your review in this case, let me back up. You indicated that you attended the Force Science Institute. And forgive me if I'm ignorant, but isn't there a little bit more to the Force Science Institute than you've told the jury? Is that considered a prestigious institution, one of the best schools in the country?
It is, and they engage not only in training but in peer-reviewed scientific research to back up the theories and that they teach.
All right, and so when you attended that school, did you just show up for a day or so, or did you do something more intensive?
No, so it was a 400-hour class over several months that not only required in-class attendance, but discussion groups. We had lectures by doctors involved in these areas, specific areas of attention and memory and human performance. We had to analyze cases, and we had to pass a test based on our analysis of those cases, and we had to prepare a written report on a case that we analyzed to be able to pass the training.
All right, so did you attend that by going in person to wherever this is located?
The first class that I did was an in-person class. I guess I should tell you, this is the second attempt at that class. I went through that class in Chicago the first time, and just as I got to the end, my daughter again had a medical emergency and went into emergency surgery, so I could not attend the 3-day evaluation, so I didn't get credit. So I waited a couple of years and was able to reapply and go back through the class. It was online, Zoom meetings, and research and study based on that.
All right, you said you had to apply. Can anybody get into the class?
No, sir. They have some requirements that they base it on. They want to make sure that the individuals that are attending this class have not only the educational background, but they're actively involved in this type of work, so that what they're teaching is actually applied in this area.
So I know you're a humble person, and I'm not trying to embarrass you, but you have to be pretty good to get into that class.
Yes,
Do you
sir.
agree?
Yes, sir.
All right. And when you complete it, do you get a certification?
I do.
And what is that certification?
The certification that I have for the last class that I took was the Advanced Force Science Specialist. Again, it's the highest certification that they offer.
All right. Now, getting back to materials that you reviewed, as part of your review, did you review Chuck Joyner's expert report that the state provided?
I did.
Did you review his supplemental report that he provided within the last week or two?
I did.
And did you read a copy of his book that he wrote on police use of force?
I did.
And do you agree with his statement in his book that women who are suspects of misconduct can be equally as dangerous as men?
I do.
And so, given what he said in his book, applying that to Melissa Perez, and what we saw in the videos, could she be as dangerous as a man wielding a hammer as aggressively as we saw her in the videos?
Not only in her gender, but in her work history and what she did for a living, it certainly makes her a danger.
All right. So let's break down a couple of things regarding that. First of all, you reviewed CPS records. I think that you may have alluded to that. Is that correct?
Yes, sir.
And so the CPS records indicated that she was a roofer.
Yes, sir.
And I believe in the video that Detective Soto had with family members, they mentioned that she was a roofer.
Yes.
Okay. And so, and getting back to Chuck Joyner, who is Chuck Joyner?
Chuck Joyner is a retired FBI agent. He worked previously in the CIA, and then he expert on use of force, but his expertise in that area, and he's got some background in SWAT and other special assignments that he did, but his expertise is more in the actual application of force, how to do the defensive tactics that we use, how to defend yourself, that type of a situation. To my knowledge, he's never investigated an officer-involved shooting case and never analyzed an officer-involved shooting case.
All right. And so, given what you saw in the body-worn cameras of Melissa Perez, is there any doubt in your mind that at 2:02:04 to 2:02:07 that she was engaged in a deadly charge that was aggressive swinging the hammer and potentially striking Alfred Flores in the back of his head?
No doubt at all.
All right. And based upon your review of various body-worn cameras of that moment in time, using the Graham v. Connor standard, did Eleazar Alejandro act reasonably at 2:02:07 when he fired 5 shots at Melissa Perez?
Yes, he did.
Why did he act reasonably?
Because he was defending a third person under the statute itself and under the current case law.
All right, and we've seen in the videos that Melissa Perez retreated to the hallway between the kitchen and the living room, and she stood up, faced the patio door, and when she was facing the patio door, it was approximately 2:02:10 or 11. Do you recall that?
Yes, sir.
And you saw that she had a purposeful look towards the door for at least a minute, at least a second or two, and then began her charge somewhere around 2:00. When she charged towards the patio door, when Eleazar Alejandro and Alfred Flores fired 5 and 3 shots, did they act reasonably under the Graham v. Connor standard?
Under Graham v. Connor as well as Chapter 9 of the Penal Code.
And why is that?
Because Chapter 9 allows an individual to use force when and to the degree they reasonably believe it's immediately necessary to prevent the other's use of unlawful force or attempted unlawful force. And then analyzing that under the Graham v. Connor standard of totality of the circumstances and objectively reasonable, he meets those qualifications as well.
All right. And as part of your expert analysis, did you review a court decision that discussed facts similar or nearly identical to this situation?
I reviewed a court decision that dealt with the exact circumstances of this case, yes, sir.
All right. And after you reviewed this court decision, did they reach conclusions similar to yours that the use of force in this case was reasonable under Graham v. Connor?
They did. The judge in that case ruled that the officers did not use excessive force, that they acted reasonably under Graham versus O'Connor, and that there were exigent circumstances for them to do so.
All right. And whether someone's schizophrenic or not, in that case, when someone's charging at officers with a blunt force instrument, does that create an imminent threat of serious bodily injury or death?
It does.
And when they close a distance similar to this case, does that cause a peace officer to reasonably believe that it's necessary to use deadly force to defend themselves or fellow officers from serious bodily injury or death?
It does.
And when you reviewed the facts of that case, did the judge require that the police officers retreat after the suspect charged at the officers in that case with a blunt force instrument?
The judge in that case did not require it, nor does Texas law.
All right. And do you agree with that under Texas law and also Graham v. Connor?
I do.
All right. And just so there's no doubt, would you agree with me that when Jesus Rojas failed to arrest Melissa Perez when he had the opportunity to do so at 12:44:32, had that opportunity for 2 minutes, that the issue of mental illness, emergency detention, was not an issue in the totality of circumstances in the Graham v. Connor when the officers used force at 20207 and at 20213 through 20217.
It was not.
All right, and why is that?
We talk about the reasonableness of the officer's action, that being objectively reasonable. We look at the reason that Sergeant Flores, in this case, made the decision to arrest, and the other two officers were attempting to, or Officer Villalobos was attempting to arrest as well. That is that subjective idea, that idea of, I think that based on everything that I have, this is my plan, and this is what I'm going to do because I believe it's correct. Now we look at objective reasonableness. We take his opinion out of it because the courts have said that if our subjective opinion was all that mattered, then we'd always be right. But that can't be the standard because we know sometimes we're not. So what we're going to do is we're going to take your subjective opinion, your belief that you were right, and we're now going to analyze it by looking at all of the facts and circumstances that are involved in this particular case and determine whether or not your reasoning was justified or reasonable or not. Based on this particular case, Sergeant Flores, Officer Alejandro, and Officer Villalobos had no indication and had no knowledge that Melissa Perez was suffering any kind of mental illness or mental break. All they knew and evaluated was her actions at the scene that, as we talked about before, could appear to be an intoxicated person, and in fact she was. So now let's look at all of those facts and circumstances to determine whether or not your decision to go in and arrest her at that time, okay, was reasonable, and we can not only look at what was going on at that time, but in determining facts and circumstances, we can look at all of the information that we've gathered at that particular time to say, did he make the right decision based on what he was doing at that time that he believed was reasonable from a person being in his perspective. Is that clear?
So one of the things that I want to digress upon, and I'm going to try to close quickly, but can you explain to the jurors the importance of action-reaction time from the perspective of a police officer and how they're trained?
The action-reaction is one of the things that we take into consideration because it allows us to determine, it kind of gives us a heads up of what could happen, what our human performance abilities are. To give you an example of what we're talking about, one of the examples that I use in class, and we talk about it being science, and there are people that are going to say, science doesn't mean anything, but the simple things can be considered science. So if I were to have you hold your hands up here, you don't have to do this, but if I was to have you hold your hands up here, and I was to tell you, when you hear me say go, okay, I want you to clap your hands before I do, okay? Because we're going to hold them up at the same time. And when I say go, I'm going to do this, and I guarantee you none of you are going to be able to do it before I do. That means, as the suspect in this case, I'm always ahead of you. I've always got some advantage on you in order to use that force against you. So we have to try and determine how long it takes us to respond to that, and we know that. We know that it takes at least 0.56 seconds for the brain to say, this is what I want to do, send them to the arms or the hands to do it. That takes another 0.2 of a second. So about 5.6. We are always behind the 8 ball or behind the suspect by at least a half a second or more. If we're in a shooting situation, if it takes us a half a second to react, and it takes us another second and a half to get our weapon out of the holster, then that individual has the capability of firing, based on scientific studies by Force Science. They have the capability of firing at least 4 shots before we can even get out of the holster and be on target. Take that into a blunt force object, it's a little bit slower, but you're also seeing that you have the ability to strike and injure or kill an officer based on the number of strikes you could do before I have the ability to react to what it is you're doing to me. So we are always behind, and we try and understand that so we can train officers how to respond to that.
All right. So I think that the next question that I have along those lines may be clear, but just in case. Based upon that training, are officers required to receive an injury before they can use force?
They are not.
And why is that?
Because of that particular incident, because we're behind the 8 ball, we're not required to wait until we get hurt. We're not required to wait until actually, and one of the things that I teach in classes is if I'm standing here, okay, talking to a suspect that's in front of me, and as that officer I'm standing and talking, okay? That individual takes a sidestep and he kind of blades his body towards me. We know from our training and experience and that's a fighting stance. They're getting ready to take that balance to get ready to strike. And also, as I see that individual ball his hand up, he's been aggressive and threatening, but he balls his hand into a fist, okay? And I know as an officer, based on what I'm seeing, an attack is about to happen. Attack to happen until I can use force. I'm able, and a private citizen who was viewing something like that would go, oh my God, that police officer just hit him for no reason. But that's why we ask questions in these investigations in the statement. Why did you use that force at that particular time? What did you see that justified you taking that action when you did? I hope that explains it.
So, one of the things that you did in your PowerPoint presentation is you presented how many times Melissa Perez said that she was refusing to be arrested, go ahead, shoot me, and on and on and on, and there's probably 40 or more instances that she cited. Is that what the Supreme Court and Graham v. Connor references when they say the test is whether the suspect is actively resisting arrest?
That's part of it. The resisting can be verbal, as it was here. No, I'm not coming out. I'm not going to comply with your orders. And in those situations where an individual is actually resisting verbally, if it was a one-on-one situation, we would be justified in using the taser in that situation. But that's something to consider. But also in the Graham v. Connor standard that we're talking about, her actively resisting arrest was her actively attacking the officers.
All right, so the 3 times that she swung the hammer at Jonathan, her statements that she was not going to be arrested, though that would inform the officers that when she was charging at them at 2:02:07 and 2:02:13, that she had the intention to use the hammer as a deadly weapon to cause serious bodily injury or death.
Yes, sir.
And that belief would have been reasonable.
Yes, sir.
And that they didn't have to wait for that to actually happen to use deadly force.
No, sir.
And is that consistent with the use of force continuum or the use of force matrix that's taught by TICO?
It is.
All right, explain the use of force continuum or use of force matrix as taught by TICO.
The use of force continuum and use of force matrix, the terminology has changed over the years since 1977 when I started up until now. And we've seen changes in terminology and changes in diagrams to help officers understand it better. But the premise of what that diagram and that system is simple. If it tells us when we would be authorized to use force or when it would be reasonable for us to use force in a particular situation. It goes for if a person is not actively resisting, it's passive and verbal. Then at that point, we're only going to use verbal commands to stop them. We're not authorized to go hands-on. Now we're going to go hands-on, which to get that individual to comply and get them under arrest. And we're able to use, if they're actively resisting, intermediate weapons like TASP and ASP and tasers and pepper spray, what other intermediate weapons that we have to accomplish that goal. When the individual to now they pick up a weapon, then that changes their perspective. And even in Mr. Joyner's diagram that he talks about in his book says basically the diagram that he came up with use of force basically says a tool or a weapon, deadly force is authorized under those circumstances. So even his definition of deadly force is authorized because you're using a tool or a weapon, and a tool was obviously the case here.
All right, and I believe you addressed Deanna Plott. She attended your course in Kerrville or Kendall County?
She did.
All right, and did you have a chance to talk to her at that course?
I did.
And can you relate to the jurors, the conversation you had with her regarding this case?
There were 6 officers from the San Antonio Police Department that attended my course, and we were actually talking about taking statements from officers in an officer-involved shooting in that particular segment of the class. On the break, I spoke to Deanna, and she came up and asked me if I was involved in the case. I told her that I was going to be involved for the defense, but we couldn't talk about any facts or circumstances. And I asked her if she was involved in the case, and she said yes, she took a statement. Because we were talking about taking statements in the class, and I had just finished talking about asking questions and delving into the why, she made the comment that when she took the officer's statement, because she didn't want to be influenced, didn't want to inject any bias in that particular situation. It's not injecting bias, and my response to her was, wait a minute, if you don't watch the video, if you don't know about the facts of what happened, then how do you know what questions to ask to get to the direction to determine whether or not the justification existed? That practice doesn't make any sense. That's why it's critical, even in officer-involved shootings. When I was investigating them, our shooting team would meet and the detectives would talk about, okay, all of that information needs to be shared with those officers, because how do you expect the lead detective to come up with a proper analysis if the detectives that are assisting and retrieving that information don't ask the questions to give that detective the right response or analysis?
All right, so given her answer, do you have an opinion as to whether, giving that attitude at the end of the plot, whether she had the ability to do a careful analysis and give proper attention to the facts and circumstances of this case?
I will tell you, based on the statement that she took and reviewing this case, at the time this case happened, my answer is no. Of course, I want to make sure this class occurred after the officer-involved shooting occurred, but based on the information that she obtained in this case, then no, they did not do it thoroughly.
All right, and based upon her answer to you and based upon having seen the statement that she took, did she have the capability to include the severity of the crimes at issue involving Melissa Perez in the decision that these officers faced?
She did, and she chose not to.
All right. And did she have the ability to properly evaluate whether Melissa Perez posed an immediate threat to the safety of the officers on the scene?
She did, and she chose not to.
And based upon her answer and based upon the statement she took, did she follow the Graham v. Connor standard on whether Melissa Perez was actively resisting?
She did not.
Now, in Detective Soto's affidavit, he makes the statement that the officers could not have reasonably believed that Melissa Perez posed a clear danger to the officers. Do you have an issue with that?
I certainly do.
And what is that?
Detective Soto clearly did not analyze the justification uses of force in here. Not only did he add information into the warrant that was misleading to the magistrate, who may have decided after reading everything that should have been put into the warrant that I'm not going to sign a warrant for murder when there was clearly justification in this case. But his miswording, and it's intentional, that's my opinion, that by putting statements in there that was only favorable to the decision that had been reached earlier was a disservice to these officers, because it did not allow the magistrate to review all the facts to determine probable cause, or even the elements of the offense of the case.
All right. Now, getting back to the court decision that you reviewed that's similar to this case, did the magistrate judge in that case say that you cannot analyze the facts of a case from the comfort of the judge's chamber, but you must consider the tense dynamic circumstances facing a reasonable officer?
He did.
And what does that mean to you?
That means exactly what Detective Soto did in this particular case, and what the administration and everybody else did in this particular case. They sat back, they looked at what happened in this case, they looked at the flawed information that they were given that didn't provide justification for this case, and they basically said, because of what the officers did, I don't like it. I don't like the fact that they did this. I don't like the way that it looks. I don't like that this appears to be improper. and they made a decision based on personal opinion. Detective Soto basically said the same thing by giving his opinion in his testimony. I don't like what happened. We can't put people in jail because we don't like what they do. We have to put people in jail because they violate the law and there's no justification for what they did. And that was not the case here. This case was an opinion, the decision was opinionated to the point where it wasn't justified.
All right. And one last thing, you consulted with Kimberly Bauer and Lisa Miller and
They're all retired, well, they're all retired San Antonio Police Department. All three worked for me. I actually recruited, Ray Bob was already there, Raymond Roberts was already there, but I recruited Lisa and Kim to come to Murders from Sex Crimes. So we all worked murders together.
all right. And all four of you I said I only gave you lunch, but you're okay with the fact that even though I retained you, that it was better and simpler for these other attorneys to question you and Lisa first.
Absolutely.
You're okay with that?
Yes, sir.
All right, thank you very much.
Yes, sir.
And Jackson, how are you?
Good, how you doing?
We've known each other a long time.
It has been.
Hope you're enjoying your time out in Kendall County.
Greatest job in the world.
When you work as a detective there or a lieutenant here, and you supervise investigators there, so isn't it true that sometimes before you have a case that's presented for indictment or filed, that you talk to the district attorney's office about the case and what you got?
It is true in some circumstances, not always. I prefer my investigators not do that because I want them to learn how to investigate cases and get involved. But there are times we seek advice, yes, sir.
Would you be surprised if that happens all the time in Bear County?
No, I worked in Bear County. I'm familiar. We would ask questions.
Right. There's a dialogue that often happens.
There
right?
can be. I was mostly not a part of that, again, because we wanted to investigate our cases and make our determination. At the end, we would contact you.
But you are and have been a law enforcement officer your whole adult life,
Pretty much.
right?
Yes, sir.
How old were you when you started?
22.
22 years old?
23. I'm 70 now.
The people that you have surrounded yourself with, and the people that you know, and the good friends that you have are in law enforcement,
Yes, sir.
right?
Yes, sir.
How many people in your life are like Melissa?
In what sense, sir?
Well, I mean, people that you spend time goes through these kinds of issues and problems.
Well, I have to tell you, my family is not the greatest. I've arrested my cousin for possession of controlled substances. I've got people that are in poverty status. I have people who are drug addicts. I kicked my brother out of my house when I was on the police department because he was using marijuana. I pretty much have experienced a lot of what's going on, and I do have individuals in my family that suffer from mental illness. So that is a big part of my life.
I mean, I guess the point is we all have them,
Yes,
right?
yes,
I mean, everyone you know has these folks that are troubled,
yes, sir.
that have issues, so, right? And that they can still be loved.
They
right?
can,
They can be misunderstood,
they can.
right? They can put themselves in situations on something. Do you agree?
If circumstances permit, yes, sir.
Right, I remember kind of as we all went through the George Floyd time period and all the protests and all the interactions and, things about, well, I have an autistic teenager and I'm afraid that if he's driving on the street, that an officer may misunderstand that what appears to be his disobedience, right?
We have those, and I've investigated those cases as well, so it does happen.
And law enforcement has to, and they do now, even more so, train officers on kind of recognizing those signs, or trying to.
They're trying to with the issue of mental illness, yes, yes, sir.
Well, because it's important, right? It's
It can be,
important,
yes, sir.
Right? said, and you repeated a minute ago, that in the officers that you supervise there, that are doing investigations, homicide investigations and other things, you tell them, leave your opinion out of it, just gather the facts.
Leave your opinion, your initial opinion out of it as you gather facts. I will not have a detective coming to me and saying, I think this person did this. No, go find the facts, analyze those facts, and give me a reason for believing that is factually, objectively factual to determine whether or not the crime existed. Did they meet the elements of the offense? Did they have the criminal intent, the right criminal intent to commit that particular offense? So leave your personal opinions out of it. Let's analyze this based on an objective standard.
But ultimately, everyone has opinions.
They do, and we're supposed to try and control those opinions as best as we can. That's what I look to do, not only in my investigations, but my people.
In a criminal trial, the opinion that matters, right, is the jury's.
In this process, yes.
Right?
Yes.
And you were talking about, the standard that the jury will be given, and that's to determine what an ordinary and prudent person would have felt or perceived given the circumstances that these officers were in. Would you agree?
Object, it's not what an ordinary person, it's a reasonable officer.
The charge will speak for itself. A reasonable, ordinary, and prudent person.
Right, and you can answer that.
I can answer that by referring to the statute and what it's supposed to talk about. And the statute talks about a person has the right, okay, to use force to defend themselves when and to the degree they reasonably believe it's immediately necessary to defend themselves against another's use of unlawful force. Now, that reasonableness standard is defined in Chapter 1 of the Penal Code, and it talks about putting an ordinary, reasonable person,
Ordinary and prudent.
ordinary, prudent, reasonable person under those same circumstances.
Right, so you expressed it well. It's not, like you said, it's not what the officer thought, right? Because in that time, nobody would ever be convicted. Charged with using deadly force against another. It's this ordinary and prudent person.
It's what the officer thought, but was that thought, that subjective intent, was that subjective intent reasonable under the circumstances based on a reliance from an ordinary, prudent person?
Right.
Yes.
It's what the ordinary and prudent person standing in the shoes of that, in this case, officer, right?
Yes.
What they perceive.
Yes, if
Right.
I'm looking at an ordinary person and I'm sitting in my house and there's an individual with a hammer that's running through my back door, through my plate glass back door, how am I going to react? Or if I'm an ordinary, prudent person facing an individual charging me with a hammer that I know can kill me, how is that individual going to react? And is that reaction reasonable?
What's your understanding of the word prudent?
Prudent is just an ordinary person. I'm sorry, I can't give you a definition for it, but prudent, I would opine that it is a reasonable person.
Well, it's kind of, you're in circles there. You can't define reasonable as prudent and then say prudent is reasonable.
Well, I actually don't know the definition of prudent from memory, so I would have to say if you ask.
Ordinary, careful person.
I have no problem with that.
You talked about Graham v. Connor a lot. Now, Graham v. Connor is a federal court opinion, Supreme Court opinion.
It is.
And it isn't a criminal case. It was before the Supreme Court in Graham v. Connor. It was a liability of a police force.
Most of those cases, you're right, are basic liability, but the fact that it's a federal opinion does not negate the fact that it's criminal cases, because in Supreme Court cases, when we talk about Fourth Amendment cases, whether or not the search is reasonable, the entry was reasonable, the seizure was reasonable, those standards, even though they're decided by the Supreme Court, are applied to Texas law enforcement officers as well, that you and I both argue every day in the cases that we prosecute. And
what it's used for is essentially, and the reason why it's used in the trainings that you get in the law enforcement agencies across the country is it's to help officers protect themselves from civil liability.
if we're talking about Graham v. Connor and that application, The concept that it protects you from civil liability, you're absolutely correct. But the premises that are determined by these cases, by these federal cases, are ones that are applied in everyday law enforcement practices. But yes, it protects us from civil liability, but it also directs us in how we're supposed to act in everyday life in Texas.
But you would agree that Graham v. Connor has nothing to do with 931 and 932, the instructions the juries will be given as to what Texas law, how Texas law allows a justification for.
The facts of those cases do not, because that case wasn't a use of force where force was being used against the officer. Graham v. Connor just told us how we're supposed to analyze those use of force claims against law enforcement officer. But the facts had nothing to do with anything similar to this case.
But it did talk about the totality of the circumstances are important.
It did.
And I guess it was another Supreme Court case this year, what was it, Barnes v. Felix, right? That kind of expanded on that.
Yes, sir.
Right? And it talked about the totality of circumstances has no time limit.
It doesn't. That's why we're allowed to, in looking at that, that's why we're allowed to look at all of the factors that occurred, not just specifically at this moment. As a matter of fact, Barnes v. Felix was a case where the Fifth Circuit, we tried to apply that all we look at is that moment that the officers used force. That's the only thing that's important. The courts tried to narrow that use of force analysis to just that second when it happened and ignore the Graham decision talking about objective reasonableness. And of course, the Supreme Court came along and said, no, we're not going to look at just that one moment in time, that 1 second that Officer Villalobos was on the railing. That's a fact, but that's not what we look at. We look at, again, the totality of the circumstances, reaffirming that in analyzing use of force cases, we look at everything.
And in this case, tell me if you agree with me, these are some of those circumstances that can be viewed in totality of circumstances in this case.
Again, yes, sir.
These are things that, from what your review of the records, your review of the testimony, so these are things that officers Villalobos, Alejandro, and Flores did know, right? They
Yes,
knew
sir.
that Melissa Perez was suspected of cutting wires to the fire alarm,
Yes, sir.
that Melissa Perez had thrown a glass candle at Officer Salinas as he tried to enter her home,
Yes, sir.
that Melissa Perez was not physically imposing given her size.
No, I don't agree with that.
You don't think they couldn't see her, how small she was?
I can tell you that they looked and saw her how small she was, but given the attacks that have been committed before they got there, then I don't think that's reasonable to assume.
Okay. That Melissa Perez was repeatedly telling officers that the whole world and all of America is watching them harass her.
Yes,
And that she was indicating that there were cameras everywhere.
yes,
And that Melissa Perez, against overwhelming odds, defiantly and repeatedly insisted that officers had no right to enter her home without a warrant.
as I stated, that was the comments that she made, but they have to be taken in the proper context. You have no right to arrest me.
She was saying that, right?
Yes,
Right? That the old man in the bed, that there was an old man in the bed in an adjoining room,
yes,
right? That although her front door was locked, 5 windows to her apartment were open. The officers were aware that she only showed aggression to those who tried to enter her home.
she attacked those. There was nobody else close.
Right? Well, the ones who were standing outside the railing.
Okay,
Okay. That officers had available for this entry and apprehension 15 fit, well-trained officers with body armor, multiple tasers, a shield, and a shotgun with beanbag rounds.
I do not agree with that statement. In certain parts of it, you're right. There was a shield present. There were shotgun, less lethal shotgun was present. And there were 15 officers that were present. However, only
Well-conditioned?
they were well conditioned. And you know what? Those well conditioned officers did not take part in trying to arrest Melissa Perez. Only 2.
Only 2. that officers had, before they made this entry, they had cover, distance, and time.
Distance and time available until we decide to take action.
That their objective was to complete the entry and extraction without anyone being hurt or killed,
That was the objective, yes.
right?
Yes,
Isn't that, shouldn't that always be the objective?
it should, yes.
Right?
Nobody wanted this to happen.
That at the time of their entry, they knew that she was within steps of being able to get the hammer.
Yes. But she didn't have it at the time they made the decision to go.
That knowing all of this, Villalobos and Flores attempted entry into her home without using the protection of the shield or meaningfully deploying a less lethal option.
That is a question that you're looking for to fit your narrative, but we've already discussed that those options would not have applied in this particular case.
You say the shield would do them no good.
I would say the shield was not designed for what the purpose it was, and going through that door with that shield would have been more problematic than not.
Okay. And you would agree these are your opinions?
These are my opinions based on my expert analysis of the case.
I agree. And Detective Soto can have opinions?
I try to be politically correct here without actually saying it. He can have opinions, but his opinions have to be based on the law, and they were clearly not. Mine, sir, are.
Chief McManus can have an opinion?
Chief McManus can have an opinion. In this case, it was clearly wrong because there was no justification for it.
His command staff could have an opinion?
Again, same argument. They can have an opinion, but it was not based on a thorough and complete investigation of this case.
You would agree that from the materials you looked at, that Chief McManus and his entire command staff signed off on this prosecution?
That question, yes, they signed off on it because they're the ones that initiated it, yes.
Okay. But you would agree that that decision to sign off on it was months after the warrant was issued,
Yes,
right?
Yes.
It wasn't until September that the case even came to the DA's office.
just as the meeting at 8:30 relied on facts and circumstances that they did not have because the investigation was not complete, that rush to judgment there, okay, was problematic, as well as the flawed and incomplete, and I've already said it, horrible investigation into this case by Detective Soto that prompted this. What else would you expect them to do? They ignored the information necessary to make the correct decision in this case.
When you left San Antonio Police Department, did you do so on good terms?
Yes, sir,
Did you have
absolutely.
any problems with administration when you left?
None at all.
Thank you, Lieutenant. I'll pass the witness.
Yes, sir.
No questions, Judge. Mr. Sifron, does anything? All right, third Steve.
Thank you, sir.
Can I ask the state one question?
Sure.
705.
gonna stay, but we're gonna let you go because we may have another one of those hearings that lasts a while without your presence. So I'm gonna let you go, come back tomorrow no later than 10:30 in the morning. We anticipate going 10:30, and I know that one or more of you have to leave by 4:30, so that'll be about the time that we'll go tomorrow. All right? Have a safe evening. See you tomorrow.
All right.
Are these 2 your numbers out?
Yeah. Sure, literature. One of the nurses is gonna leave because he said she told her husband to pick you up and eat.
If you have an extra copy.
I'll ask.
Yeah. Or donut or something. Bear claw. Squish it.
Like, I'm gonna go ahead and start putting this stuff all the way.
Yeah, I can
I
certainly.
don't think they need it.
No, they won't. Not for the expert.
Well, remember, the best thing you have is pharmacy. Yes. Yes. I give you what's.
Oh, no.
outside the presence of the jury. Lou is on the stand. They may proceed.
All right, let me swear you in. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
All right, if you could give us your name and spell it for the court reporter, please.
Yes, my name is Angelos Leiloglu, and it's spelled ANGELOSLEILOGLOU.
All right. Stay.
Good evening.
I am looking at your resume of a Master's of Architecture from Texas A&M, a Bachelor of Environmental Design also from Texas A&M, correct?
Yes, sir.
And your field is photogrammetry,
Yes, it is.
and if you could tell me what that particular field is that is it suggests, is it hard science based on a look at your educational background?
Yes, photogrammetry is the science of attaining accurate and reliable measurements from photographs.
Okay. And what is the underlying science behind that ability to obtain accurate measurements from, this is still photographs?
Of course, a video is just a series of still photographs, so
Okay.
it can be used on video as well.
What is the underlying science behind that whole field? How is it applied?
So it's applied by using two things. One is the principles of perspective, developed in the 1400s, and an area of math called projective geometry.
And how do those two areas, how do they come together to allow you to obtain, I'll ask your forgiveness for the late hour,
No problem.
obtain the desired information?
Yeah, so it's through triangulation. We're trying to measure points. So by being able to view a point by two different directions, we can triangulate its position in 3D space.
Okay, and then once you have one point, you determine another one, and those become, associate them all in a particular area, I'm assuming.
Something like that. Yeah.
Is there a specific technique in applying that theory? How many different theories are there in the process of achieving your end state? Is there just one that's commonly accepted, or are there alternate and competing theories?
No, they're not competing theories. I mean, it's basically math. So it's like you get it right or you get it wrong.
Alrighty. And the field of photogrammetry, how long, I've heard about and seen your recreation of the JFK assassination. Is that where else is your field used? Besides that recreation that I've seen you do?
Oh, I do that every day on a daily basis. That's my expertise.
What are the tools you use to?
So there's technology that we use, LiDAR. You've heard the Leica being spoken about. That's our base. That's a device that captures a million points per second. So you have all this data, and you apply that to these photographs, so that you can get to within millimeters of accuracy. What we're doing is trying to do it's called reverse projection. So we're trying to take a 2D image that we have, video, and we're trying to project backwards to find out where that camera that took that picture was, and then from there we can look through that photograph through the lens of that camera, and then we can recreate or reconstruct what was seen in that camera itself.
Now, we've already heard this jury's already heard testimony about how the body camera, which is the source cameras for the videos, which are the still photographs you had, it has some inherent error in its lens. How do you account for or remove that error from your original still photograph?
Sure, that's called camera calibration and part of photogrammetry. And so it's going to first calculate that lens distortion, is what you're talking about, and then correct for it.
Okay. And so these are all commonly accepted practices within the commercial railroad field. That commonly accepted practice, it has, I'm going to assume it has specific methodologies that you have to follow to get your in-state.
Yes.
And you've applied those in this instance.
Yes, sir.
What information did you look at to start inputting to develop your finished product? What information were you given?
I was given body-worn cameras, scene photographs. You're saying that I actually used, or just that I've reviewed?
What you actually
Actually
used and reviewed.
Reviewed. I was given also some 360-degree images that were taken by the SAPD. I believe that's all. You know, there's photographs of the weapons. There's photographs of the officers, things like that.
You said a 360-degree images taken by SAPD?
I believe they're SAPD. Yes.
Do you have those images with you?
Don't know if I have them with me. They're called OSCR 360.
Okay.
Yeah.
The OSCR, thank you.
Yes, sir.
Once you get your raw material, once you get your material, what's the process you go through? You calculate those known distances, and then what happens?
So first we have to have a base, and that base is the Leica scanner or 3D laser scanning. It's not a Leica that I use, but it's a similar device. That's our basis. Like I said, it can capture 1 million points every second, all accurate to within just a couple millimeters. So that's our base. You have to know some known measurements of the scene, and then you can apply photogrammetry using that data to come up with the reconstruction.
The Leica scan, did you do that yourself?
I did. It's a LiDAR scan. I used a Trimble scanner. It's a different brand.
All right.
Mm-hmm.
And it's your testimony that you applied those techniques properly in this case?
Yes, sir.
One of the charts that's been given us to review, you produced a point of view viewpoint from Officer Alejandro. He was the officer standing on the ground outside. Because from his body-worn camera, he's standing on the ground beneath a concrete platform. His body-worn camera does not show his weapon or aim point. So how were you able to develop, how did you account for the in-state product where you do have his weapon and aim point?
Yes, sir.
How did you compensate?
It's not compensation. It's been recorded by other cameras, other body-worn cameras. You can see him in multiple cameras, so you can then triangulate his position of his weapon, position of his legs, position of any limb on him, his head, all that stuff is triangulated because there's multiple cameras.
Okay. We've heard testimony about how an officer's stance, aim point is common sometimes to have both feet aligned. Some may prefer maybe to blade themselves slightly. I'm not aware of any body cam that shows Officer Alejandro's feet all the way down while he's shooting. How did you account for that from the other cameras? I know the principal one would be Thompson to his left, you've got officers behind you.
Correct.
But no weapon, you can't see his feet, at least to my knowledge. So what all went into giving the rendition in your finished product for Officer Alejandro's weapon and point of view?
For his weapon or his legs?
Well, will you agree that knowing his feet, that would help support his point of view for his weapon? And I'm simply saying, I don't know how you got it. So did you have to make any estimate? Everything still precise? Do you have any variables? What are the variables that are?
So, for example, like if we know where a hammer is, and we can't necessarily see all the arm, we know at least the hand is touching where the grip is, right, or the handle. So the same thing with a body. If we know where not the whole body is there, but a foot is on the ground, we can have a margin of error where, say, their legs are. But if we can see their torso, we can assume that's right underneath. So there's some, yes, for parts that we can't see and measure, we know his height, and we can use a average skeleton to try to match or track his position.
All right, so there's some margin of errors in trying to get his feet and his foot. Are there margins of errors in that calculation?
There are margins of errors, but so if we can see it clearly, the margin's smaller. If we can't see it clearly, then there is some margin of error that's calculated by the software itself. So I guess that answers your question. Yes, there is some margin of error, and in any photogrammetric analysis, there's going to be some margin of error.
And those errors, when they're identified, does the software, fill in and compensate? Is there a printout where it tells you what those possible errors are? If somebody wanted to check it, how would they go about it?
Well, the errors are really on the calibration of the camera. So it'll tell you how well the camera has been calibrated. Then whatever we can see through that camera, we're matching where those objects are.
Has the end product that you produced or products like it, have they been used in Texas frequently, many occasions?
By myself?
Yes, sir.
Yes.
How many times?
At least.
What type of trials are these?
Two of them are officer involved, and one it was a car lift accident, industrial accident kind of thing.
So, were they criminal trials?
Actually, I take that back. There's 3 officer involved and 1 car.
Where were they? What counties in Texas?
Tarrant County, 1, Dallas, and Austin. You should have my history, I think.
At least the document I'm looking at only shows your education, experience, paragraph on forensic visualization, research teaching, professional affiliations, publications that I see off of this document, and that's the first thing I get when I click on your name, about using it in criminal trials in this state or any state. Is there something else I should be looking at?
I thought you'd be provided with it, but I have a copy if you want me to
Please,
grab it.
please.
Judge, can I go grab it?
Yes.
back to that, error rate. And I don't wanna misstate. I did hear you say that there's certain margin for errors for the things you can't absolutely know. Is that accurate to what you said?
Yes. So if not whatever's seen in the footage, we can match. But if we can't see it, and I'm not sure exactly if Mr. Officer Alejandro's feet can't be seen, but like I said, we can make an assumption of where his feet would be, considering his size and where he's standing.
Okay. And what is that potential error rate or that margin of error? What is it?
I calculate it to be about 3 to 4 inches.
So you got body-worn camera footage, reports. Did you use still photographs as well?
I did.
And then you use the OSCR.
No, I didn't use that.
I thought you said you did use old.
I reviewed
you
it.
Reviewed it.
Yes, sir.
From the, with the, is it appropriate to call it 3D simulation in your in-state?
I'm not sure what you're
I'm looking
describing.
at, okay, I've been looking at what we were handed as a flash drive. It has, approximately 81 PowerPoint charts, and the last 30 or so have what I'm calling a 3D animation or projection.
Sure.
That's the in-state product you created.
It's a visualization, yes.
Okay. And I'd ask, with your opinion, how would this help the trier of fact reach a decision, your product? How does this help the jury reach an ultimate decision in this case?
Well, first of all, the reason I was asked and tasked to come up with the measurements, I'm measuring basically the reconstruction that's been created, is to provide one of the other experts information that he would use. I also think that being able to show from the officer's point of view what they potentially could see would help the jury in their decision making.
No further questions, Your Honor.
Did you want further questioning, Judge, or is that sufficient?
It's sufficient for the court.
Okay, yeah, we'll just save it for when we obviously proffer them in front of the jury. And that we intend to use his PowerPoint presentation as a demonstrative.
Okay. Anything else?
That's it. Yeah,
All
that's
right.
much good.
Tomorrow at 10:30.
No, that's for you. Yeah.
Cool. Thank you.
Excuse, Judge.
Yes.
Thank you. Have a good
Yes,
night.
sir. You too.
Oh, this is over here as well.
10:30.
Roger.